Okay, really interesting situation that we have here with this witness. Again, the idea of what was found at the crime scene. Now, I'm being told, I hope we have him with us. Joining us right now is criminal defense attorney Pate. Mr. Pate, are you with us here on Law and Crime?
I'm with you. Can you hear me?
It's great to have you here. Great to see you. And now I want to just talk about the Merritt case. There's so many moving parts in this trial. People are probably confused. Do we expect this to last for months?
I mean, that is the expectation that we've been given from both the prosecution and the defense team. But I would be very surprised if this trial continues longer than a couple, 3 weeks beyond today. They have really focused, I think, the presentation of the case on the key elements, what the prosecution in this case needs to prove as far as the elements of this particular crime. It is common for lawyers to give a longer estimate of a trial to judges, potential jurors, just to make sure that there are no conflicts so that they would later have to be excused from the case.
Yeah, that's a good point, and clearly we have so much to talk about in this case. I'm glad you're here. We're going to take a quick break. When we come back, it's Law and Media time. Stay tuned here on Law and Crime. Okay, let's break this down right now. Now, Mr. Pate, what they're basically saying, in the way that I've understood it, is that, and they've had kind of a big win last week where they had a lead detective who said that he doesn't believe the killings happened in the house. If we accept that, if you're sitting on the jury and the killings didn't happen in the house, is it impossible that Mr. Merritt didn't commit this crime, that it happened in the desert? I mean, again, how much is that a win for them?
I think it's a big win for the defense. I mean, the more you hear as this case kind of, evolves during the trial, there's more and more reasonable doubt to suspect that Merritt is the guy that killed him. I mean, the evidence in this case is so thin, I am very surprised it's a death penalty case, because one of the first things that prosecutors will tell you, they're not going to seek the death penalty unless they have a rock-solid case on guilt or innocence. And here there are so many holes in this case. The evidence is incredibly thin. And now you have the lead detective saying the prosecution's theory about the initial murder doesn't even make sense based on the evidence. So I think it's a big win for the defense. We'll see if they can use it effectively.
Well, let's just talk about what the prosecution has. Yes, they have access, they have motive, they have a relationship, they have the fact that his cell phone was pinged in the area of the grave site, they have tire tracks that may match his car, they have the QuickBooks account, the fact that he had a financial motive here, was taking money out of the account. What do you say to those items of evidence put forward by the state?
Well, I'm hoping in the defense's case we're going to hear more expert testimony about these cell phone pings. They're not nearly as accurate, I think, as we've heard them portrayed so far in this case. There are a lot of holes there, a lot of reasons why his phone may have not been in the area, or even if it was, I understand he may have relatives in the area. That alone is not sufficient to prove that he committed these brutal murders. I mean, given the nature of the crime, it's horrific. The fact that the tire tracks may have matched a car similar to his, he doesn't drive the only car of this kind in the United States. All of this adds up to suspicion and probable cause, but does it overcome reasonable doubt? I just think we're wrong.
And what about those QuickBook accounts? I mean, really, that's the thing that I think most people are harping on.
Well, so he cheated his partner, perhaps. It looks like this other guy, Kavanaugh, also stole some money from this guy. I don't think a financial motive is enough to justify this type of crime. If you have motive without any other physical evidence, and I understand there's DNA evidence in the car, there's an explanation for that as well. It's very tempting for us to just listen to the state's case at this point and accept it as all true. But I'm expecting during the defense presentation of the evidence, you're going to hear this challenged, you're going to hear different facts, and perhaps expert testimony to try to put some of this in context and show that there is sufficient reasonable doubt here. That's just my take.
Well, listen, one of the reasons this case has captured so much attention is you could take what we're learning about and argue it from both sides. It's a murder mystery for a reason. Let's take a quick break. When we come back, we'll analyze some more of the testimony and the evidence presented. We'll be right back. All right, let's talk more about the who. And the prosecution is saying that Charles Merritt is the person who did this, but they're also saying he covered his tracks in different ways. So let's focus more on the who when the prosecution continued with their opening statement.
The who is the person who desperately tried to cover his tracks after the murders. The who is the person who, excuse me, in attempting to cover his tracks, the evidence will show he misled investigators, he talked in circles, and he played the victim. The who is the person who, even after the murders, took $5,000 from Joseph's mother under the guise of completing a project and never paid her back. The who, ladies and gentlemen, is the defendant. And those lies and that misleading, that talking in circles and that playing the victim worked for a time, for almost 4 years. This is the McStays. In 2010, they lived in a town called Fallbrook. They moved into the residence in November of 2009. Prior to that, the family lived for a brief period of time with Joseph's mother, Susan Blake, in the Tom's Farms area, just south of Corona. Fallbrook is a town that's south of Temecula, north of Escondido, north of San Diego. They moved into the house at Avocado Vista Lane, there near the end of a cul-de-sac, into a quiet neighborhood. They drove 2 vehicles. The green Dodge you see here in the driveway of the residence, the evidence will show was always parked there, and typically Summer drove that vehicle. The family also owned this white Isuzu Trooper that Joseph primarily drove. Joseph had a business. The business was called Earth Inspired Products. The business started...
Okay, let's break some of this down right now. Back here with Pate. Mr. Pate, you talked about the weaknesses in the prosecution's case. Well, in their opening statement, was there something that caught you and said, you know what, that's something they should stress on a little bit more? They're still putting on their case. We don't know how long it'll last. What do you think they should really stress on? What's their strongest piece of evidence against the defendant?
It appears their strongest piece of evidence is what you referred to earlier. There is some financial motive, and there's obviously some mistakes Merritt made after the case or during the investigation and after he became a suspect. But that's not at all uncommon for suspects, criminal defendants to give inconsistent statements to police, to talk in circles, as the prosecutor was saying. That happens. That's the real world. What I think they're missing here is any direct physical evidence to tie him to the crime. So I would stress, if I was the prosecution, the cell phone data, the fact that they can show him in that location, and the DNA evidence they've apparently found on the vehicle's steering wheel and gear shift. That's what I would focus on, the hard evidence, something that may persuade a jury.
Now, the burden's not on the defense, but how much do they have to prove this idea that Daniel Kavanaugh did it?
That is a great question, and that's the temptation, right? The defense thinks it needs to go in there, present a different story, and then prove their story is more believable than the prosecution's. Don't do that. This case is tailor-made for a reasonable doubt defense. The defense lawyers cannot assume the burden of trying to prove a different set of facts. All they have to do is show reasonable possibilities. And if those possibilities still exist at the end of the trial, that's reasonable doubt.
Yep, and it's going to be up to the jury. A lot to decide for them in this case, and it's only a few weeks in. Tell you what, we're going to take a break. I'm going to be signing off. Bob Bianchi is going to be signing in. And remember, we are expecting to be live in that courtroom any minute. This is a really exciting case. We're entering into another day. Who knows which way the testimony will ultimately go? But I'll tell you one thing, Bob is going to guide you through it. So we'll be right back. Stay tuned here on Law and Crime, and we'll be back live in the McStay family murder trial. Stay tuned.